Hey everyone, today is January 11th, 2024, and I'm here with Bruce Pardy. We're hoping to have a discussion. And Bruce, you can certainly correct me if I'm wrong, and I will appreciate that. Um, but I hope that what we get to discuss today is um, tightening up the bullseye and getting to the heart of the matter and getting everyone clear on what the heck is going on with these negotiations with the WHO. The difference
Right.
between
Yes.
international law and national or federal law or state or provincial law, and the conversation could be vast, but I think I want to let you have the floor. Please introduce yourself and set the stage for what it is you want to discuss.
Okay. Thank you. Thank you, Jim. Thanks for having me. Uh, yes, this is a bit of a tangled web. I'm a law prof in Canada. I run a small think tank called Rights Probe. We're a law and liberty research outfit, and I've been looking at the proposed WHO, World Health Organization, new pandemic treaty, so-called, and the proposed amendments to the international health regulations. And there's been some considerable discussion about these in certain circles, and justifiably so. They are a problem, and the difficulty is in trying to figure out what the problem exactly is, as you alluded to, because it involves the relationship between international law and domestic law, and there are parties involved, and it's difficult to figure out who is doing what and what the gambit actually is. So I'm really happy to be here. Let's try and take it apart.
Okay. I want to clarify. I've been trying to do this for 2 years. We're talking about two separate tracks of negotiations. There are amendments
Right.
to the international health regulations. There is a set of negotiations run by the Intergovernmental Negotiating Body, and they have had version after version after version. It's had many, 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 many names. The commonly used terminology, for good or for bad, is the pandemic treaty. So for
Right.
sake of this,
Right.
even though I
Yeah.
don't really like that terminology because I think we need more precision, but we'll talk
Right.
about the treaty or the amendments. And they're
Okay. Good. Good. Good.
they're
Great.
they're they're different, but the bigger picture applies to both. And we've had a handful of conversations, and the issue comes down to a lot of things, but one of them is, the question of sovereignty, and
Right.
what kind of change to sovereignty might either or both of these documents have an influence on, have an impact on.
Right.
And it's a term. I don't want to put you on the spot, but what the heck is sovereignty?
Right. So, okay, sovereignty, if you like, is the first principle of international law, and that is that nations have exclusive jurisdiction over their own territories. They can't be told what to do. International law is the arena in which they interact, and let's just take a step back. Let's just talk about international law for a minute, because it's a very strange phenomenon. And I'm going to generalize because it gets very complicated. But think about it this way: there are two different systems of law. There's domestic law, which we're all familiar with. National governments pass legislation, and states or provinces pass legislation as well, and courts apply that law, et cetera, et cetera. That's domestic law. International law is a different animal. It's the law, at least public international. This is a bit of a tangent. There are two different kinds of international law. There's private international law, which is the law that courts apply to figure out when parties make international contracts, from one party to one country, one party's in the other country. What do you do with that when a contract is breached? Okay, that's not what we're talking about. We're talking about public international law. Public international law is the law as between countries. And the units are the countries. For the most part, individuals, there are exceptions, but for the most part, individuals don't feature in public international law. So international law is the relationships, the legal relationships that the countries try to make between themselves. And sometimes it's multilateral and global, like the UN, the WHO, the climate change pacts, and so on. And sometimes it's bilateral or trilateral, 2 or 3 countries get together and make a deal themselves. Next, there are 2 different categories of countries. There are what are called monist countries, that is, one system countries, and dualist countries, that is, 2 system countries. And the difference between them is that in a monist country, they regard international law as simply part of the law. So if their country enters into a treaty, makes binding obligations in international law, the courts will apply that law as part of the law. The dualist countries, the 2 system countries, regard these 2 systems of law as different and distinct. And the law that applies in the country are the country's laws and not international law directly. And the only way for the provisions of a treaty, for example, to be applied in that country by that country's courts is for the legislatures in that country to implement, to adopt, to legislate those provisions into domestic law. And in those countries in particular, you can end up with this peculiar situation. You can have a country that is signed on to a treaty and promised certain things to other countries. And those promises can be regarded as, quote, binding in international law. And those promises, those provisions can have no legal effect in that country because the legislatures in that country have not so legislated. So, for example, if you have a statute in that country that conflicts with the provisions of that treaty, then the statute applies and the treaty does not. So when we say that something is binding, we're talking with respect to those countries. And by the way, those dualist countries, those 2 system countries tend to be the Anglo-American common law countries. The US, UK, Canada, Australia, New Zealand, and so on are dualist countries. They have this 2 system idea in their legal system. So in those situations, in those countries, it is possible for their executive, the president or the prime minister or whoever, to sign a treaty that creates so-called binding obligations in international law and to have those promises not legally enforceable inside that country. Which gets me to the question that you asked about sovereignty, right? So if you have a country that signed on to this WHO treaty, but those ideas have not been incorporated into the domestic law of that country, then those promises are binding within the meaning of international law. But the country must legislate itself. So those promises do not take away the sovereignty of that country to decide its own laws. So this WHO treaty idea is a very bad idea. We'll talk about the details, but it's a very bad idea. But it does not mean that if your country signs on, that your country has lost its sovereignty.
That will shock a lot of people. And because there's 194 member nations to the WHO and 2 additional nations, the Vatican and Liechtenstein, who are party to the international health regulations. And at the moment, no one is a party to the treaty because it hasn't been, finished. It's currently going through a rewrite. And, until May, when if they get 2/3 vote to adopt it, it would still have to be, each nation would have to decide whether or not they want to be a party to that treaty. So, a lot of this is off in the future. But because there's 196 answers to that question on a certain level, how does this get implemented in all of these various jurisdictions or nation states, parties, as they put it? You're in Canada,
Mhm.
and for sake of
Mhm.
clarity, let's, for the remainder of our discussion, let's just talk about Canada, because
Okay.
we don't want people misapplying what we're saying here to wherever they may live. If anybody wants
Right.
to have that discussion, for their country, be happy to do it. Um, I have observed, correct me if I'm wrong, that
Mhm.
there's a definite distinction between the authority within, and again, we'll just keep this to Canada. Within Canada,
Mhm.
there's a definite distinction between who, and I don't mean the WHO, I mean, lowercase,
Yeah.
who has the authority to enter into a multilateral agreement, and does the Canadian Parliament have any authority in that making of a decision, as opposed to, obviously, what you were just talking about, legislating it, into effect? I hope I got my question out
Right.
clear.
I think I understand. So the federal executive has the power to enter into treaties. So they in international law, the federal executive can bind Canada. Um, that does not require uh, the agreement of the provinces, who have their own legislative jurisdiction. It does not require agreement of the House of Commons or the Senate. It's a federal executive power to enter into treaties. Now, as a matter of practice, the federal parliament is often sometimes asked to ratify the promise made to enter into the treaty. But the important point for my money is the difference between agreeing and ratifying on the one hand, and incorporating and legislating and implementing on the other hand. Those two things are quite distinct,
I,
right?
I want to
So
linger.
back
I
to
want to
my
linger on this topic. This is a topic,
yes,
of confusion. Would you be kind enough to repeat what you just said and then keep going?
yes, and this is a point I think that people have great difficulty with because it doesn't make much sense. It is possible for a country to have entered a treaty and to have made those promises in international law, and yet to have that law not apply in the domestic law of the country, because the federal executive has the power to enter treaties, but the federal legislature, that is Parliament, and the provincial legislatures with respect to their own areas of jurisdiction, they have the power to create the laws that apply inside the country. And that's the function of sovereignty. So on the one hand, and this is a lot of this is about language, right? So in international law, the international law people, the international lawyers and so on, insist that when a country signs a treaty, that country is bound by the promises that it makes. The promises are binding in the language of international law. Okay. But that doesn't mean that the law is suddenly changed inside that country. In Canada, you can make a promise to enter a treaty, but if Parliament doesn't agree to pass legislation that's consistent with it, and the provinces who haven't made the treaty don't agree to change their laws to be consistent with the promises, then the promises do not apply inside the law of your country. Now, let's make it specific for a minute. A lot of the public health restrictions that were going on during COVID, a lot of those fall within provincial jurisdiction. Provinces in Canada have primary jurisdiction over healthcare and property and civil rights. So a lot of those rules were implemented by provinces. Now, if the federal executive passes, or sorry, not passes, but agrees to, signs on to a treaty that agrees that the country will implement any WHO recommendation, which is what's being suggested, the provinces can say, well, but those particular recommendations that the WHO is making fall within our legislative jurisdiction, and we don't want to do that, so we're not going to. Right? So you have a binding promise in the treaty, and a province that says, nope, sorry. And the federal government, the federal executive has the power to enter the treaty, but the federal executive and the federal parliament, neither one of those has the power to dictate to the province how the province is going to exercise its legislative authority within its constitutional jurisdiction. And so you can have this funny situation where, yes, you have a, quote, binding obligation on the part of the country, but the province is not obliged to legislate accordingly.
On a larger level than most people think of it, I will not comply. If the nation or the province, or you could get in other areas, whatever organization says, no, our sovereignty, our rights, our freedoms are to be protected, go take a hike. Right? Now, let me turn that around, right? And I often refer to the World Health Organization as the World Hypnosis Organization. And so
Yes.
if when you're a child and your parents say to you, you have to do something, ooh, there's a lot of power there. The power differential is really big, and you kind of have to. When you get to be an adult and your parents say you have to do something, you kind of go, well, I'm not going to comply with that. And so what we're dealing with here is compliant officials who
Yes.
get a recommendation from something like the Director General of the WHO and choose to comply with that binding. Okay, they've agreed to comply, so they're going to try to get you to comply. And whether that
Yes.
is you being the country, the province, the person. And so I had a little experience where we ordered a package from somewhere, and it wasn't to be delivered to the home. It went to a local package pickup center during the lockdowns and all that craziness. And so my girlfriend knew that this would get under my skin. She goes, "Oh, look at the tracking, right? It said, oh, when you go to pick up your package, make sure you social distance and wear a mask." And it was guidance from the WHO. And so it made me laugh,
Yes.
because it's like, well, that's a nice recommendation, but I don't got it. And so
Right.
is that a reasonably decent analogy? If you think you have to, when someone says you have to, but it's not come down into the jurisdiction, and it's there's the whole question of what is legislated, and is that legislation in a violation of your rights and freedoms. Putting that aside for a second, just because the WHO says so, and just because your federal government says that they wish to comply with that internationally binding agreement, just their agreement, if it hasn't filtered down and hasn't been done in a manner that is within the authority of whatever legislative body or executive branch decree, sovereignty is also personal. And so if you can talk on that, I know that's a big topic, but anything you care to discuss about that, please do.
Yeah, well, but I think you're putting your finger on the real danger that this plan represents, right? So I've described the situation where, strictly speaking, the promises made under the treaty and the regulations are not directly implementable inside Canada without action from the federal government, or the federal legislature, or the provincial legislature, as the case may be. But that presupposes that those bodies and the authorities inside the country don't want to, which is not likely to be the case because that's not the game. The game is that the WHO will be given this apparent authority, and then the domestic authorities will follow it because they want to follow it, because they don't want to have responsibility themselves for making the call. So they are likely to say to all of us, oh, but these are binding WHO recommendations, and so we have to implement them. And so here are the rules. And I'm sorry, it's not our fault, but we're just following our orders. And this argument that I'm making, which is, well, not actually binding upon you in domestic law, that is going to be completely ignored if those authorities want to go along. And based upon the previous experience, you can certainly expect that they will largely want to go along with the heavy-handed measures that the WHO might recommend next time around. So in my mind, this is a bit of a gambit or a shell game, in that you sign on to these documents. They're binding international law, but they require action from your domestic governments to implement. And those domestic authorities will pretend as though they are binding in domestic law and go ahead and implement, and thereby nobody will be responsible. Because you can't, we as individuals can't hold the WHO responsible because we have no relationship with them. And now it will appear as though it's not our domestic authorities that are dreaming up these rules, it's the WHO. So there's power everywhere and accountability nowhere. This is a way to avoid the buck landing on your desk.
Exactly.
And for that reason alone, I think it ought to be rejected.
At the risk of being redundant, I really want to ask you to walk through that whole thing again. And I'll do it in my words and then do it again and correct me if I'm wrong.
Okay.
Any international agreement that someone has, a head of state has signed on to and said, yes, we're going to try to comply with this thing. They then have to get legislation. They may try to do it by decree or whatever other method, but unless legislation is enacted to implement and bring the nation into strict compliance with that, there's no law. Okay, and the people who make the law might implement it, because there's a lot of stuff I want to talk about, the details. They might implement it in a fashion that is within your constitutional or charter or rights, however that may be. But they don't strictly have to. And if they tell you that they have to, they're a little bit mistaken. And understanding what your rights, what your freedoms are, and what authority they may or may not have is where the hypnosis settles in. And someone says, "Oh, I have to. I can't, not my problem. It's I'm just doing my job." Okay.
Right.
And no, you're choosing to do your job in that fashion, but you don't have to. And if you're doing your job in that fashion and you're trampling on my sovereignty, my rights, my freedoms, that's where people need to understand that it's not a foregone conclusion. There is a way to block all of this in every way, shape, or form. If a province was to pass legislation that was clearly in opposition to whatever the heck this international agreement might be, I don't want to overblow this, but kind of sort of game over for them. They've set their rules that are in conflict with what is perceived as legally binding.
Yes,
that's my crack at it.
Essentially correct. Yeah, that's not bad. Let's untangle a bit, but essentially right. So let's take that clear situation. So let's say the federal executive enters into a treaty that obliges them to do certain things. And the province, within their constitutional powers, legislates in contradiction to those provinces. Let's say a province legislates such that they say, people are not required to do the following things, unlike what the WHO recommendations were. Okay. Well, in case of a clear conflict in an area of clear provincial jurisdiction, the provincial legislation will prevail. Okay? But it's often not that clear. And so in the murky gray, here are the kinds of things that can happen. So you might have existing legislation at either or both of the federal or provincial level that is not inconsistent with the treaty you've signed on to or its rules, and gives the executive in either the federal or provincial situation the power to pass regulations or directives or orders of the like under the legislation. Well, now those orders or directives or regulations can be made to be consistent with the promises you made in the international regime, right? And so that doesn't require legislation because the legislation already exists that delegates the power to the executive branch. The only clear case is where you have domestic legislation that conflicts with. The other wrinkle in this is that although the international regime is not directly enforceable in the domestic sphere without more, it can be used by courts as a reference by which to interpret ambiguous statutory or constitutional terms. So strictly speaking, it's not a part of domestic law. On the other hand, the presumption is that statutes and constitutions in domestic law are to be understood to be consistent with international obligations and international norms. Okay, so it is not true to say that it has no effect at all on domestic law. It can have an effect. It's just that the legislatures in question still have the sovereignty to legislate in contradiction to it if and when they want to, but they often don't want to. Okay? The other thing we might back up and just cover is this question of the meaning of binding in international law and why we can tell that countries do not surrender their sovereignty when they sign on to these things. And by sovereignty, let's go over this just one more time because it's a very important point. By sovereignty, we don't just mean short-term control over specific things. You can, in fact, effectively lose control over that, especially if your own domestic authorities are cooperating. So the people will lose control, yes, but that's not what sovereignty means. Sovereignty is jurisdiction, the government jurisdiction over your own territory. Now, how can we tell for sure that countries don't surrender their sovereignty when they sign on to these things? Well, because they retain the ability to change their minds. So when the UK joined the European Union, it lost control over all kinds of things. They promised to follow EU rules on a whole list of them. And yeah, in that respect, the people in Britain lost direct democratic control over the making and enforcing of those rules because it was a matter that the European Union was doing. But the UK was still a sovereign country. And how do we know that? Because they were able to decide they'd had enough and they wanted out. Brexit is an exercise of sovereignty. So whenever you have the choice to turn around and change your mind, that means you're still a sovereign country. On the question of whether or not a thing is binding in international law, this is about language. And so international law authorities will insist that when a country signs on to a treaty or the like, those promises are binding. Okay, but binding does not mean the same thing in international law as it does in domestic law.
Bruce,
binding in domestic law means.
Could you say that again? Just say that one more time.
Yeah, sure.
Because this is where words don't always mean what you think they mean, and that's that's legalese. Go ahead.
Right. So imagine this. So imagine that you get together with somebody and you make a contract with them about something, and you breach the contract. You know, you get paid and you don't do what you promised to do. That promise that you made is binding on you, in the sense that the other party with whom you contracted can take you to a court and say, look, we had a contract, I paid him money and he didn't do what he promised. And the court will say, you breached the contract. And here's the remedy. You know, you return the money, or you provide this, or here are the damages. And if you don't do what the court orders, like return the money, then eventually there would be a way to enforce the order of the court. And eventually that will involve the police. Eventually, maybe not right away, but eventually, if you refuse to do what the court has ordered, the force of the state will show up in the form of the police, and you will be in contempt of court. Okay, that's what we mean by enforcing a binding obligation. In international law, there are no courts like that with the physical coercive power to enforce orders against unwilling parties. And the parties are countries against each other. One country says, well, you promised to do this and you didn't do it. Okay, well, that may be a breach of a, quote, binding promise, but it's not binding in the same way, because there's no place to take the other country to a court and have that court say, you will do this or else. That's not the way this works. This is a function of international politics and international relations. Countries breach international law all the time. They breach their promises all the time. And sometimes there are political consequences, because other countries don't like it. You know, you get kicked out of a regime, or there's sanctions, or there's punishments of various kinds. But it's not like going to a court and having the promise enforced, right? So the conceptualization of that idea, the binding idea, is a completely different idea in these two spheres. If you just, for example, just consider climate change, the climate change regime that most countries belong to. They've signed up to the Framework Convention on Climate Change. They signed up to the Paris Accord. And in those documents, there are obligations. Every country has made a promise of some kind. Some of them are onerous and some of them are not. But they have made promises to each other to meet a certain emission target. And now that's not strictly under the accord, but it's adjacent to it. It's related to it. Now, a lot of those countries haven't met those targets. They have breached their promise. And what has been the consequence of breaching their promise? Well, the other countries have said, you have breached your promise. What else has happened? Nothing.
Let me interject here.
It's all a matter of, yeah.
I'm going to put up an image that people can pause the video, and then we'll continue the conversation. And this is what I'm going to talk about. All right, so I had posted what I'm about to read in the video here, and so you can always go back and pause it and read what I'm about to say. But what I have in my hand is the October 30 version of what they call the Proposal for Negotiating Text of the WHO Pandemic Agreement. Now, this is currently being rewritten, and we expect to see another version early February, or whenever they deem it worthy to put out, so that all the little people around the world can see it. So take this with a grain of salt, because I'm reading from the very last page of that 30-page document, Article 34, the settlement of disputes. And I don't think we're going to have any dispute, because I think this is saying exactly what you have been saying. So paragraph 1 in Article 34, settlement of disputes. In the event of a dispute between two or more parties concerning the interpretation or application of the WHO pandemic agreement, the parties concerned shall seek through diplomatic channels a settlement of the dispute through negotiation or any other peaceful means of their own choice, including good offices, mediation, or conciliation. Failure to reach a solution by good offices, mediation, or conciliation shall not absolve the parties to the dispute from the responsibility of continuing to seek to resolve it. Big whoop-de-doo.
Right.
Okay.
Exactly. Yep.
That's how this gets enforced in international law. Now, it may change.
That's right.
It may change.
Yep.
But that brings us really to the point of where is the battle that we face? Okay. If they enact this legislation, whatever you want to call it, treaty, amendment, agreements, all these sort of things, where does the rubber hit the road? The rubber hits the road
Yes.
with the local government official who's going to not let you do something because they go, oh, the treaty. If they don't
That's right.
adopt this, where does the rubber hit the road? Oh, with your local official who says, oh, the prime minister said, or the premier said, or we have to because of some reason. The battle on an individual man and woman basis is pretty much always the same. It's just what is the intensity of the hypnosis and the propaganda and the confusing legal language where someone is trying to infringe upon your rights and they go, oh, we have to because. Oh, talk amongst yourself. Go ahead, Bruce.
Yeah, no, that's absolutely right. The problem is the same as it was the first time around, which is those authorities in your own governments who want to use a heavy hand to tell you what to do. They were the problem first time, they will be the problem the second time. They are the ones who are signing on to the treaty, who are pretending the treaty obliges them to do something. They are the ones that have democratic accountability to you to the extent that they do. These international bodies, the United Nations, the WHO, and so on, I think we should conceive them this way. The United Nations, for example, although it's become a big unwieldy problem, but it was conceived as a meeting place. Like it's a place where countries come together to talk and work things out. That's what it was supposed to be. And the same thing you could say with the WHO. The World Health Assembly is a collection of officials from the various countries. It's a meeting place. The WHO, if you like, is the plaything of all the countries together. In that sense, in a way, it doesn't really exist, at least not with respect to you and me and the rest of the public. We don't have any call or claim on the WHO because it's not our thing. It belongs to the countries. We have a claim on our representatives in our governments. Those are the people that we vote for. Those are the people who are answerable to us. And they are the ones going out and playing with the WHO. So that is our answer. Our people who are imposing rules on us, they should be answerable to us. And the game here is to provide a smokescreen that looks as though, oh, they're just doing their job because they've been told what to do by somebody else with authority. That is not true.
It's a classic, there's probably been many, television shows, skits about you go to some government office and or maybe you make a phone call and they forward you to somebody and they forward you to somebody. Not my job. I'll connect you here. I'll connect you there. And then you come back around, you're talking to the same person, you go round and round and round. I think you've described it as a shell game. Okay. And
yes.
So again, so as not to confuse people, we're talking about Canada just because that's where you're from. You're not there now, but that's where you're from.
Right.
And the issue is, what do people do? Well, if you're pushing in the wrong direction at the wrong or pulling the wrong lever, okay. I have a vision of a Far Side cartoon. It really stuck with me. It's a kid trying to get into a school building, and he's pushing real hard on the door, and there's a sign up above his head. He can't see it. It says "pull," right? So
Yes. Yes,
if
I know
you're
that cartoon. It's great. One of my favorites. It's the School for the Gifted.
yes, yes, and so um, you have to understand where and how to push, and who you're lowercase who you're dealing with matters, and the conversation that you have with
Yes.
them matters, because if you are speaking with someone who does not have authority, or if you're speaking to someone who has authority in a certain realm, the conversation needs to be appropriate. And so
Yes.
um, you had in a conversation that we had the other day, you told a little story. I hope we can recreate it, because it I think it will be impactful for people. Um,
Mhm.
and I am living it right now, because there's meetings going on with the WHO, and in the bottom, the very last sentence in the page, in regards to the 14th general plan of work that they're having, it lists all of the organizations that they have relationships with, that they are requesting comments from. And the last sentence says,
Mhm.
no comments from individual people, please. And you just go, wait a minute, okay? We don't have
Right.
standing as individual people. And you told a little, made up story about
Yes.
um, people who have a group have contracts with each other, and you're not a party to it. If you could recreate that, that'd be spectacular.
Sure, sure. So just imagine that you get together with 20 people to make a contract about something. Maybe you're building something, you have a project together. And that contract contains all the promises you make to each other about the money and the plans and the rules and so on. And in that contract, there are details about deadlines and obligations and procedures. And let's say along the way that one of the parties to this contract that you have breaches the procedures that are set out in the contract. They miss a deadline or something of that nature. And somebody else, not one of the 20, but somebody else off to the side, sees that they have breached this procedural requirement in the contract. And they come up and they say, hey, that guy has breached the contract. He can't do that. We have to make him not do that. And they can't. They have no standing to do that because they're not a party to the contract. They can make no complaint about the behavior of one of the parties to the contract unless they're party to the contract themselves. That's contractual privity. It's none of their business. That's an analogy to the WHO situation in this sense. The WHO agreements are agreements between countries. And those countries are the parties with status to complain about the behavior of the other parties. We as individuals are not part of that agreement. We have no status and no standing to complain directly about anything. Our only option is to complain to our countries who themselves are parties to the agreement. And if our country, our executive parts of government don't care about the breach of somebody else, then it doesn't matter. And nothing we say will affect that.
I resemble that remark, okay, because I am not a party to the international health regulations, okay? I am
Right.
complaining about the way they conducted a vote for the amendments in 2022. In my view, they violated their rules. A couple of countries have rejected those amendments. It's believed, Iran and New Zealand complained, and they go, nope, we reject that. We don't want anything to do with that. Not necessarily about the vote, but just the substance of the amendments. I'm
Mhm.
raising awareness of a future complaint that I'm going to have that I don't have standing to have, but I'm going to complain anyways to, government, national government, where there's a deadline coming up, January 27th, January 27th, where amongst this group of nations, it appears that the working group for amendments is going to violate their own rules. Well, if nobody there cares, they're just going to let them do it. Okay. And so that brings forward, the question that everyone, should have: what do we do? How can we do something? How can we help? What is it? Well, step number one is to do what we're doing right here, which is to get clear on the details. And if you're pushing back in a way that is inaccurate, you're not only not going to be successful, you're missing the target. And so let's try to talk about, what can people do in terms of expressing their opinion about all of this. Now, part of it is these documents are changing. And I have been saying for quite some time, I don't really want to get in this conversation down into the weeds of all of the details because they're all in a state of flux. But in many ways, in many, 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 many ways, these documents are a venture capital prospectus to take public money and throw it into the pharmaceutical, hospital, emergency, industrial complex and build out the infrastructure so that they can scare the crap out of us. Okay. Now, that being said, who do you complain to about an aspect of this? And what can you proactively do? As you said, if there's legislation pushing back against any aspect of this, or if, public sentiment is, and, one of the things that we're both aware of is in Canada, CanadianPetition.com. Now, in and of itself, that's just an expression of public opinion. It's not going to write legislation. It will hopefully encourage someone to write legislation, but we can do that on every level. There are friends that I have who in Florida on a county level, actually, it's got the same phone number that you have there. I'm going to have to get you connected. I know people 45 minutes away from me in Palmdale, California. They pushed on their city council and got an ordinance saying, no mandates for this, no mandates for that. And in Palmdale, California, they didn't have to worry about that. In various counties around the country, legislation or ordinances, whatever you want to call them, have been passed pushing back. Got a good friend, Karen Bracken in Tennessee, dealing with state nullification of federal encroachment into the rights that are guaranteed here in the United States under the 10th Amendment. What can people do, understanding that whether an agreement is reached and the propaganda and the hypnosis gets stronger, or an agreement is failed, even if they fail to reach an agreement, the battle is not over because the battle is in your home territory.
Yes,
the floor is yours, Bruce. The floor is yours.
Well, I agree with where you're going. So the political sentiment at the moment, I think, is the most powerful tool. Let's just eliminate something. These WHO proposals are not obviously unlawful. I mean, you can't sue the WHO for going down this road. You can't sue your national executive for pursuing the agreement or signing on to the agreement. It's a lawful act. It's within the competence of the national executive to do this. So this is not at first glance a matter for the courts, because the courts are going to say, well, what are you here complaining about? So it is a matter of political sentiment, and that depends upon persuading enough people that this is a toxic idea. And if enough people believe that, and that trickles down to those people who are elected and begin to believe that their own success depends upon them rejecting the idea, then you get something to work with. But you can't just shout into the void. If you can't shout at the WHO officials, because the WHO officials really don't care. They're not answerable to you. They're there to answer to the forces that are imposed, they're being imposed upon them, which are from governments and these other international forces that want them to do a certain thing. And of course, they're being pushed and pulled in various different directions in their own circles, right? But yelling from the outside from us will not influence those particular officials, I think, inside the hierarchy of the WHO itself. The best call that we have, as you say, are on our own local, state, and provincial and national political figures. They need to come to the conclusion that their fortunes are better off if they reject these ideas instead of embracing them.
I have personally sent many emails to all of the members of the United States Congress and Senate, but also the Canadian members of Parliament, Australian members of Parliament, UK members of Parliament, New Zealand, and I've got quite the collection of response emails, which are both entertaining and enraging at the same time. And
Right.
to summarize them, because sure, they're different, but essentially, oh,
Yep.
we would never do anything
Never do that.
never do anything to, take away your sovereignty. No, we would not give away our national. No, 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 no. We would never infringe upon your rights and freedoms. And then, you go, boy, collective amnesia. You most certainly would. And you probably already have, because the legislation that is currently in force, I think you mentioned this earlier, gives various officials power to do some ungodly things. And so
Yes.
what we need is, a cleaning of the house of, what is the current legislation. They might not need to enact any more. They may very well already have laws that empower them, or at least appear to empower them, to do all of the crazy things that they did over the past 4 years. Now, very specifically, I know we're talking primarily about Canada, but in the past week or so, Libby Klein in Australia, I republished her article. She pointed out that, the health minister might as well be God in Australia. And I know from a year ago, they passed legislation in Western Australia that it makes your spine shiver. It's just, good Lord, the dystopian, powers that are being given. We need to have people dig in and understand at a local level. This battle is just starting, or they're going to continue to do it.
Oh yeah. Oh sure, sure. And at the base of the battle is an idea, and the idea is the problem. The idea is that it is appropriate for government, with its expertise and technocratic know-how, to be in a position to tell us all what to do. As long as people embrace that idea, we have a problem. And that's the idea at the base of what happened the first time around, and it's the idea that resides in the WHO plan. The premise is there are some people with expertise who have the appropriate authority to tell us all what to do. We have to get rid of that idea. That's the managerial idea. And as long as people are thinking, this is my opinion, as long as people are thinking that what happened the first time around was simply a series of policy mistakes, those people who had authority, didn't consider the science properly, or didn't make the right call on this, or didn't weigh costs and benefits properly. It's a series of policy mistakes. We shouldn't allow those policy mistakes to be made again. Well, they were definitely policy mistakes, but that misses the point for me. The point is, we shouldn't have people with the authority to do these kinds of things, whether or not they've got the science right or not, whether or not they've considered costs and benefits. It's not their job, I think, to do that kind of thing. And as long as we continue to believe that society must be managed by an expert technocracy, you're going to have a problem.
I want to leave it there, but I want to make sure that you've had the opportunity to say whatever the heck it is you feel needs to be said. So the floor is still yours. But what you just
Listen,
said
I think
is
that's
the core. Is the core.
yeah, I think that's a great place to finish off. I really appreciate the opportunity to have this conversation, Jim. It's great to talk to you. And listen, you've done stellar work on this subject. It's been a great help to me. And so thank you very much for bringing this issue to the fore. You've been the leader on this file. So I really thank you for your work.
I don't know how public you want to be, but whatever work, however people might connect to you, give yourself access, however people can access you. Please share whatever information you
Yes.
have.
So the best way is our website. Our think tank is called Rights Probe, and the website is rightsprobe.org. That's all one word, rightsprobe.org. And thank you for asking the question.
You bet. And so everybody knows that they can call me directly, 310-619-3055. All my info is on jamesroguski.substack.com. I want to repeat that one more time, okay? If a treaty is adopted or not, if amendments are adopted or not, it's still the same issue. It's an illusion. It's a shell game. It's, legally binding doesn't mean what you think it means. Okay. There's a quote from Princess Bride, you keep using that word. I don't think you know what it means.
Exactly.
And it
That's
means,
right. That's right.
and it
Yeah.
means different things to different people. But
Yes, and means different things and means different things in the different realms of law too. Yes. Yes.
and so what we are facing is, not to oversimplify it, but two ways of thinking. Oh, we get to tell you what to do because somebody said we could. Or wait a minute, no, you don't. We have rights, we have freedoms, and there's a limit to your authority, even in an emergency.
Yes.
Yeah. So we all have to stand up and understand that if you're shooting at the wrong target with the wrong, ammunition, I don't want to make this into a war scenario, but if you don't properly express your rights, freedoms, and more importantly, what kind of future do you want, and work to make that happen, they're going to continue to trick people into believing that, oh, we have to do this because somebody told us we had to do this. And that's just not adequate. It's not acceptable.
Totally agree.
Okay.
Yes.
Let me give you the last word.
Oh, listen, that's a great last word. I'm not sure that I can improve on what you just said. It's really important to get this story straight so that you don't waste your efforts chasing the wrong target. For me, as I alluded to earlier, the target is the idea, and the idea has to be changed. The idea being that people believe in the necessity for managerial bureaucracy, whether it's at the domestic level or the international level or both. That is the idea that has to be conquered, as far as I'm concerned.
Thank you, Bruce.
Thanks, Jim.